Good morning, everybody. My name is Autumn Lowry, and today we are going to go over the 6 methods to use when conducting an investigation. Appreciate everyone's attendance here today. I'm just going to have a minute here to make sure I can get through these slides. All right, before we get going with the content, I want to go over a couple of pieces of information, what to expect during this webinar. All of your phone lines are muted, so if you have any questions at any time during the webinar, feel free to go ahead and type those in the questions or chat feature. We will be addressing all questions that are provided during the webinar at the end. We believe this webinar should probably run about 30 to 45 minutes is going to be my portion of the talking, and then we'll have an additional 15 minutes or so for any questions at the end. But again, feel free to go ahead and put your questions in as we go through, and they will be addressed. You will be receiving some supplemental information in the presentation following this webinar by Friday, and again, that will contain the actual presentation as well as additional resources. We do welcome any of your feedback, so would appreciate it if after the webinar you would take a quick moment to respond to the survey. We do have a number of other webinars coming up, so be sure to check out our website and look and see if there are any topics you might be interested in. A little bit about myself. As I stated, my name is Autumn Lowry. I'm the Manager of Professional Services over here at Business Controls. My areas of expertise are in conducting corporate investigations, conducting workplace violence threat assessments, as well as conducting trainings. I conduct trainings on various topics, including workplace violence, sexual harassment, and process of investigation. I also do several webinars such as this, as well as in-person trainings. In addition to the trainings, I do manage our team of investigators and actually participate in conducting workplace investigations. My specialty are in areas of EEO Title VII complaints such as discrimination, sexual harassment, retaliation, and also have experience conducting investigations related to substance abuse, theft, fraud, and other general employee misconduct. Business Controls is a provider of incident reporting, case management software, and risk consulting services. It was founded in 1994. We have over 22,000 clients in over 22,000 locations in 130 countries. I work on the professional services side of the organization. We also have a technology side that provides that incident report and case management system, and we utilize that system while we are in conjunction with the workplace investigations. All right, let's go ahead and get started. Today we are going to examine in detail 6 methods of investigations, and I'm going to bring to your awareness some of the legal complexities and risks that are associated in conducting workplace investigations. Investigations are largely driven by information. However, not all sources of information are created equal. The information that we gather are going to come from a variety of different areas. They could be public sources, private or confidential sources, self-generated resources, or even unlawful sources. It's important that when we are looking at our evidence, that we are always checking the source and ensuring that it is accurate. Simply because a resource is available, such as through the internet, does not mean that it's going to be lawful or accurate. So you want to make sure that you are looking into those types of things as you review the different evidence. You also want to ensure that the evidence is competent or credible, it's relevant to the case, and that it is material or significant to the issues that you are gathering. You should be gathering your evidence in a lawful manner. When we get and drill down some of the different methods, I'm going to talk about in detail what it means to gather it in a lawful manner and how you go about doing that. As we go through the 6 methods, we'll also discuss circumstances for when it is best to use each method and considerations that you should look at when reviewing each method. You can use one method of investigation, or you can use a combination of several methods throughout the course of an investigation. Just make sure that you are looking at things such as how practical it is, the costs, and potential legal implications of those methods. Some methods are more expensive than others. Some methods are easier than others. So it's always our goal to get to the information in the most expedient manner using the resources available. So we may be able to use 3 different methods and they're all going to give us the same information. So let's go ahead and choose the one that's most practical. All right, first method of investigation is physical surveillance. Physical surveillance is very similar to physical security and involves people. In the most simplest form, physical surveillance is watching people, places, or things. It's often a covert method, meaning we are doing it without anybody else's knowledge. It's probably one of the oldest forms of investigation and most widely used prior to the invention of technology with electronics and the internet. All you need to conduct physical surveillance is something to watch and somebody to watch it. Physical surveillance differs from other forms of surveillance in that it has a human observer. So there's actually someone who's going to physically be sitting there watching the situation or watching the person. Because it is simple, it can be relatively inexpensive. Now the problem you run into with physical surveillance if you are watching a person is you probably don't know the patterns of that person at this point. That's why you're watching them. So you don't know how long someone's going to have to sit there for to discover that information. So it can rack up the hours, and there's just no way to predict how long someone will have to sit. So while the base fee of physical surveillance may be inexpensive, it really can add up quickly over time. While physical surveillance is inherently simple, that often makes it a top choice or a top method for people to choose. However, it should not be defaulted to when other methods of investigation are available. The times that we use physical surveillance is if we believe somebody is lying and we want to try and catch them in that lie. Substance abuse investigations as well as vandalism and sabotage are other good situations when physical surveillance can come into play. Now what you do want to consider is reasonable expectation of privacy and the limited application of the physical surveillance. So just because you observe somebody walking out of an office with a box on it that says, with a sign on it that says company property, doesn't mean that that person is taking company property off of the site. You don't know what's in that box. It could be their own things. So it's only, that information is only going to be used as corroboration when you actually conduct an interview with the person. It still may be important information, but that box or that observation in and of itself will not be the smoking gun for you. Expectation of privacy. We have to consider this whenever we're doing physical or electronic surveillance. The general rule of thumb as far as expectation of privacy is if a person, we like to share that if a person feels comfortable enough to change their clothes in that environment, then they probably have an expectation of privacy. So let me explain what I mean by that. I think we all are familiar and are aware that you can't put cameras in bathrooms. Well, that's a very private place. There are stalls. People feel comfortable engaging in activities such as changing their clothes, as that's behind a closed door. When we look at people's office spaces, what are some things that are going to decrease their expectation of privacy? Well, you want to see if the employee has a door. If they have a door to their office, can they shut it and can they lock it? If they can lock that door, who has access to it? So if it, for example, if an employee has a door that has a lock, but they don't have a key to it, and the head of the company and there are some other, the admin assistant has the master keys to it, so several people have access, then you are decreasing that person's expectation of privacy. Also, if you put windows on the door or next to the door without blinds, again, you're decreasing that person's expectation of privacy. we need to be thinking about that if we're going to go into somebody's office and take property that they have in there for evidence as part of an investigation. If somebody feels that they have an expectation of privacy, then that could possibly cause the evidence that you've collected to not be able to be used. So that is why we want to consider the expectation. In addition to that, another consideration is evidence preservation. So when you, it's always, evidence preservation is referred to as the chain of custody. That's the term that we use to describe the identification and the control of evidence from the time it is collected until it is actually used in court. The chain of custody is essentially a receipt for movements of the evidence, and it's going to protect the integrity of the data. In its most simplest form, and it is just, you can just have a form that is titled chain of custody, and it's going to detail what evidence you have and where it moves. So who has the evidence, what is their title, what's the date that they received it, and what's the time, and at what point does it get transferred to another person. When that evidence is in its sitting state, you need to make sure that you are placing it in a secure place that's locked, that other people don't have access, again, so we are protecting the integrity of that evidence. The second method of investigation is electronic surveillance. Now, electronic surveillance is very similar to physical surveillance. The only difference is that it replaces the human observer with electronic technology. So just like physical surveillance, it is relatively easy to use, and it can be inexpensive depending on how much money you put into the cameras. It can be as simple as placing a covert camera in a work area or installing some kind of surveillance software on an individual's computer. Just like physical surveillance, electronic surveillance should only be considered as corroborative evidence. So again, just because you can view somebody on the video engaging in a certain behavior, oftentimes you're not going to have the resolution that's needed in order to clearly identify who that person is. That's the biggest problem we run into in investigations. We'll have an organization that will come to us and say, we have this person on camera stealing something. So in this one particular situation, we were doing an investigation for a metals company, and they had surveillance footage of a gentleman pulling, after work hours, pulling his truck into the building. He then used the company forklift to go around the warehouse and take metals off of the shelves and place them in his pickup truck, and he then left the facility. Now, because the camera was located in a high corner of the warehouse and it had poor resolution on it, we weren't really able to clearly identify who the person was or the truck. We were able to see that it was a truck. We were able to identify it as a Ford, but we couldn't see the license plate. The camera was black and white, so we couldn't tell the color. The organization told us they were convinced they knew who the individual was because the person was walking around with these bright white tennis shoes on. And the person they suspected did it, they claimed, had these bright white tennis shoes, and he spent a lot of time cleaning them, and that they were really noticeable. Well, they were very sad to know that we could not rely on that information to identify this person as a suspect. So they felt that that video evidence was all they needed to terminate this employee. And we had to explain that this is a data point, and this is good information to suggest that you believe it may be this person, but the video in and of itself is not going to be enough grounds. We need to take that information from the video and use it in an interview with a suspected individual as information to try and get them to admit to the behavior. In addition to it being used as corroborative information, electronic surveillance has significant legal considerations, particularly when thinking about recording individuals. The most recent thing coming to mind as far as would be the Electronic Communications Privacy Act. So that's regarding wiretapping or listening to people's conversations or recording those conversations. You need to make sure that you're aware of where your state stands on this. This is regulated by state law of whether it is a two-party state versus a one-party state. Two-party state means that the person doing the recording and the person you're recording has to be aware that the recording is happening. In a one-party state, only the person doing the recording needs to be aware. You do not have to tell the person that you are recording that you are engaging in that recording. Now, while in those one-party states, that is permitted by law, generally we recommend in conducting an ethical investigation that if you are going to record an individual, particularly if you're going to voice record them during an interview, that you go ahead and make them aware of it regardless of where your state stands on the issue. Wiretapping would follow under a federal regulation, and that is not ever allowed. That's something that only the government is going to be able to authorize. So only if you have police involvement could that be a potential method for you. So lastly, just when thinking of electronic surveillance, if you have an incident that's happened and you're going to retroactively put in cameras, say there's been certain theft going on and you want to figure out who's doing it and you don't have cameras, so you think, well, maybe I'll throw in some extra cameras to see if we can catch the person. Make sure that you are getting good quality cameras. If you're going to bother to put a camera in, you might as well spend the money to get the good resolution, make sure it's in color, and make sure that the information you get is going to be able to be used. If you cheap on the money that you're spending on that surveillance, it's almost as if you didn't spend the money. So I would almost not even recommend doing that method unless you have the money to invest in it. All right, the third method that we have is research and audit. So research and audit involves the collection and examination of information from both the public and private sources. Most investigators tend to use the words research and audit interchangeably, but that is not accurate. Research is going to refer to the public sources, whereas audit's going to refer to the internal organization access or more private sources. On the research side, up on in the PowerPoint, you can see some different examples of information that we can gather. We can look at criminal records, civil records, Department of Motor Vehicle records, sometimes usually with a release, and that again is going to have to apply according to state law. Real estate, professional licensing, any kind of public domain research. So that's looking at social media, LinkedIn, Facebook, and things like that. We use research and audit in almost every investigation that we conduct. Research is going to apply when we're really trying to figure out the character of this individual, any previous behaviors that they've engaged in to kind of see if they have any patterns of behavior. So while the research is public records, most of you guys probably have releases to do some of this information searches, and it makes it really easy to make sure you're gathering the information on the correct individual. So most of the time when employees first fill out an application, they're signing some kind of release that is acknowledging you can do some kind of background check. If the employee is involved or the subject of an investigation, that does authorize you to look into this additional information. The release, what's unique about the release is if you have that signed at the time of employment, that could allow you to look at some things that are a little more private, such as the DMV records or something like a credit check, because you could not do a credit check without having a full release signed by your employee. This next slide goes into more of that public research, so looking at Facebook, Twitter, Google searching. When you go in to do a Google search of individuals, look to the bar on the left-hand side after you've done the search. There's a lot of descriptive words. There's everything, images, videos, news. You can click on all results. There's just a bunch of words in that panel to the left-hand side. Make sure you click on those and use those and explore them. Make sure you're familiar with them, as they can all lead to different results. Also, a couple of quick Google tips for you guys. When you're researching, you should always search your subject's name. Google search their name, their address, their date of birth, and their social security number. That can give you some additional public domain information. You should put your search criteria in quotes. That'll help narrow down your search. If you are going to combine several different search criteria, make sure again that each one is in quotes, and then you include the plus sign between each one of those. Google Maps and Google Earth can be very helpful as well, especially when you're doing physical surveillance or any kind of, when you need to understand the comings and goings of a person. It can really give you that live shot so that you know what you're getting into before you head out to the site. On the other side, we have audit. So as I stated earlier, audit is going to be looking at those private records. These are primarily records that are held by the organization internally. We always review the personnel file of our complaining party as well as our accused individual. We want to see the history, the context, what's going on. Has this person been accused of this before? Does the individual who's making the complaint, have they recently been disciplined? Have they recently received any kind of performance evaluation? Those are the types of things that we're checking for in the personnel file. You can look at access control records, payroll and attendance records. Those kind of things are going to speak to their patterns of behavior. When doing fraud investigations, obviously it's going to be a hard focus on documents, and that's all going to be audit documents, financial records, quality records, and things like that. Research, as I said earlier, research and audit can be used in pretty much every type of investigation. Any investigation you have involving people, there's going to be an opportunity to do research and audit. I can't even think off the top of my head the last time I didn't use this method during the course of an investigation. Things you want to consider, the availability of records. So when you are looking at public records, there are different types of public records available. For example, if you are wanting to understand somebody's criminal history, sometimes an organization or individuals will go online and pay, $25, $35 for an online search of a criminal record. The problem with those online searches is that they are pulling records from national databases, and national databases are not accurate and do not contain all of the information. Criminal records as well as civil records are reported at a county level. Those counties may or may not report up to the state level, and they may or may not report into any kind of national level. At this time, there is no requirement for counties to be reporting that information up to some national database. There's no kind of legislation that requires all that information to be held in one central location. So you want to make sure you understand where the information is coming from. Here, when we conduct our research for our clients, we are getting the stuff pulled at the county level. So not only can we ensure the accuracy of the records that we're getting, it's also going to be timely, because we're not going to have to worry about any potential delays in reporting, because as it gets processed through the county system, that's how we're going to have access to it. Also, you don't know how reliable some of those online resources are, so I would definitely tend to try and go with an organization that has some kind of expertise in this type of area. The fourth method of investigation is forensic analysis. So forensic analysis would include all manner of investigations that employ science or some kind of scientific method. Some examples of forensic analysis could be chemical and substance analysis, fingerprint analysis, computer forensics, some kind of forensic documentation analysis. Forensics is typically going to be something that you outsource to a specialist. So not many organizations are going to have these types of people internally to conduct this type of analysis needed. We use, because we're a specialty firm in that we conduct workplace investigations, we do have some of these specialists on staff. Our most frequent form of forensic analysis that we use in investigations is computer forensics. Computer forensics can reveal a lot of information. It's most commonly going to be used in investigations for things such as burglary, fraud, any kind of trade secrets or proprietary information. It gives us an opportunity to look at people's emails, review documents. It doesn't matter if somebody's deleted a document off of their computer, there is still a record of it. It doesn't matter if they never actually saved it to their computer, there's still draft records when documents are created. The only way to completely get rid of something on your computer is to use some kind of scrubbing software that will, or to actually remove the hard drive. And if those two things are done, we can also tell that. So computer forensics can reveal a lot of good information. However, you do have to consider the evidence acquisition and prevention. If you're going to take a computer and look at it, do not touch that computer and do not look at it personally. You need to get it immediately to an expert and let them do it. Don't turn on the computer, don't turn off the computer, just take the computer from the employee as it is and give it to the expert. I know that we have several organizations, I've had several incidents where an organization talks to me about doing computer forensics, they gather the computer and allow their internal IT or security director to look around the computer and see what they can find first before they turn it over to us. That is disturbing the integrity of that evidence. You never want to look at the actual computer. You need to complete a whole image of that hard drive and then work off the copied image of the hard drive. We never want to work off the original. So I urge you that if it is a situation where you need to put the investment of the money and time into doing using the specialty method of forensic analysis, to take it and not mess with it, not let anyone have access to it, and really turn it over to those experts. The reason computer forensics is a specialty is because there's not a lot of people that have the skill and knowledge to do all those things. So if it's necessary, please turn it over for those experts. Maintain the proper chain of custody as you're flipping the computer between third parties, subcontractors, specialists, and things like that. Computer forensics, while the information is pretty solid, it's a pretty solid document trail, it's good evidence to go off of, it can be expensive. So depending on what you're looking at, if you have 6 computers that may or may not have certain information, that's going to cost a lot of money to examine all 6 of those computers. So you might want to utilize some other methods to see if you can narrow down what computer it might actually be on, to try and decrease the amount of money that you're investing. I know that imaging and analysis of a computer hard drive can run anywhere from $1,500 upwards of $5,000 for one hard drive, and that of course depends on how large it is, how much information is contained, and whether or not there's testifying in court and things like that, but it can get really pricey really quick. So while the information is very helpful, you definitely want to strongly consider that you used all the methods to narrow down where these specialty efforts need to go. The 5th method that we're going to cover today is undercover. Undercover investigations are nothing more than placement of a properly trained and skilled investigator into an unsuspecting workforce. So you're going to have an investigator, or what we refer to as an undercover operative, actually placed in the workforce as an employee. So they will be engaging in the daily tasks and roles in whatever placement that they are. Their goal is to gather information as they're conducting the daily duties of those jobs without being identified. Undercover investigations are extremely complicated. They're often lengthy and not sustainable for all environments. While undercover is interactive and it allows the investigator to manipulate the environment, and get some answers from the other participants, like I said, it is extremely lengthy, and there's a certain amount of trust that's going to have to be put into place before people talk. A lot of times we're using undercover, or undercover most frequently comes into play in situations such as substance abuse. We generally recommend other methods of investigation to be attempted before undercover, but there are some circumstances where it is most appropriate. The things you have to consider is the skill of the individual. So we need to make sure that we have somebody who's fully qualified to provide to engage in the work in that particular workforce. But then they also have to have the education, skill, and experience to make sure that they're not going to be detected by any of the other employees, any members of management. Not only is the operative going to get paid for the work that they're doing, but then they also have to get paid for being an investigator. So that's where some of the pricing can really rack up. One of the chief distinctions between undercover and other forms of investigation is that the undercover investigator attempts to go unnoticed. So they want to be completely concealed as to their true identity and purpose, and it's usually to everyone in the organization. So they have to be really careful when they're out there in the field. If you are going to use an undercover investigator, it should be used as a last resort. You need to use a qualified vendor. So how do you determine whether or not somebody is a qualified vendor? You want to make sure that they are licensed in the particular state where the undercover is going to be conducted. They should have some kind of experience, some kind of reputation, so ask for references. See if you can contact any of their previous references to see how those undercover operations went. They need to have a willingness to testify in the case that it goes to arbitration or some kind of court hearing. So I would check that they have experience in testifying in these types of situations. Ask for an example report so you can see how they're actually documenting their undercover efforts, and ensure that they do have proper insurance. So they need to have proper insurance for the operative that they are placing at the facility. The last method that I'm going to cover is interview and interrogation. While the term interrogation is often negative, it's been stigmatized, the actual definition is a formal, systematic questioning of a subject for the purpose of obtaining information. We tend to use the terminology of interview over interrogation because of that negative stigma. Interrogation suggests that we are employing a particular method of questioning that's often associated with police officers, some kind of coercion, threatening, something like that. So we like to refer to it as interviews. We put our interviews into two different categories, two distinct different types. We have administrative interviews, and so those are going to be interviews that are providing some kind of insight into the incident or some kind of process. Generally, these interviews are more casual, and the tone should be polite and conversational. Some types of people that would fall into the administrative interviews are direct witnesses, process owners, anyone that has any kind of character information or context, environmental information related to the allegations. The other type of interviews we conduct are investigatory interviews. These interviews are reserved for those who we know or have a strong reason to believe they have committed an offense. The purpose of conducting an investigatory interview is to fulfill our due process obligations as well as to obtain an admission. So by the time we get to our investigatory interview, we should have a pretty darn good belief that that person engaged in the alleged behavior. We're going to have that understanding because we've used multiple other methods, such as interviewing other individuals, research and audit, and all the pieces are connected and directed towards this one person. Because you know that information going into that interview is going to be conducted with a different tone. So you will always be treating the individual with dignity and respect. You always want to be professional in your interactions, but you may go, you will use different techniques during the investigatory interview with the goal of obtaining that admission. Interviews are pretty simple. They're our favorite default method to use. They're interactive. So if you have a skilled and experienced investigator, they can manipulate the interview in order to gain the information that they need. They're high in evidentiary value. What is the smoking gun in an investigation is getting an admission. If you get someone to say, yeah, I did it, doesn't matter whatever kind of evidence you have them admitting to the behavior. So interview is going to be the best way to get the most solid evidence to be using in an employment decision. Interviews are fraught with legal risks, so there are a lot of things you need to consider when conducting an interview. A big claim that individuals try to make is one of entrapment. So entrapment is something is one of the legal issues that is pretty misunderstood by investigators. Entrapment, by definition, is getting an individual to commit a crime that they did not already contemplate. So, for example, I think people think of the police officer, setting up someone in a sting operation, trying to engage them in services. Well, the claim is, well, I wouldn't have done that, but they asked for it. As long as the police could make the argument that the person would have engaged in that behavior regardless of what they were asking, then there is no opportunity there for entrapment. Now, a private citizen cannot entrap another citizen. Thus, the entrapment defense is not available for us in the private sector investigation. So since employees cannot use entrapment as a defense, they will try to make the claim that they were held against their will in the interview room. So there are a couple of things you can do to try to combat that claim. At the beginning of our interviews, we do a series of disclosures. One of those disclosures is that we explain the conversation is voluntary in the sense that if they need to take a break at any time or they have something else scheduled, we absolutely can accommodate that. We ask that if they do need to take a break, that they just let us know so we can do it appropriately. So that way you're giving them the opportunity to take a break if at any time they want to. If they try to come back with a claim that they were held against their will, you can reference back to your notes, why give them an opportunity to take a break. If you have an individual and your interview lasts longer than, say, an hour and a half, you should make them take a break. So, if you're at the hour and a half point and you think you're really close to wrapping it up, of course, feel free to go with the flow of it and let it go through the process. But you should not ever keep somebody in a room for 3 or 4 hours straight without permitting them a break. It's important to force those breaks. Hey, why don't we just take a break, get some water, I'm going to step out of the room. That way, again, if they try to raise one of those claims, you can always default back to, well, remember when we took that break. Make sure that you note the time you took the break in your interview notes, when you broke and when you returned for the interview. Another way to decrease the likelihood or decrease the liability of getting one of those involuntary commitment claims would be to set up the room in the most appropriate way. So you want to set up the room such that the individual has free access to the exit. So do not lock the door behind them. Make sure that the door is unlocked and that they have free access to it. Now, with my background being in psychology and working with criminals, I was always taught that I should be closest to the door for my safety. And in this situation, we do not want to do that during these types of interviews. If you fear for your safety, you probably shouldn't be conducting that interview. Or you need to bring some kind of other executive protection in to make sure that you're safe. My default, a way to compromise with both of them, is that I make sure myself as well as the subject have equal access to the door. So I put the table in the middle, and then we both are seated in such a manner that if either one of us had to get out, we could. Neither of our paths are obstructed by any furniture or by one another. A couple of other things to consider during interviews. We talked briefly about the safety, confidentiality. Confidentiality is a tricky topic right now. Recent NLRB ruling has put forth that basically individuals can no longer have the blanket policy of asking interviewees to keep the information confidential. So there are certain circumstances when you can ask somebody to keep the information confidential. That's one of the supplemental documents that we're going to give you after the presentation. It's kind of a guideline to go through to know when you can ask somebody to keep it confidential and when you can't. Make sure that your policy should be generally not to ask the other person to keep it confidential, and when you're going to make an exception to that, you will have that clearly noted in your report or in your interview notes so that you know when those differences are. Another thing to consider is request for representation. So this is going to apply two different ways. We have requests for representation regarding union as well as regarding attorneys. In general, employees have less rights than we do as individuals. They do not have a right to have legal counsel present. They do not have a right to choose which union they want to represent them. They do not have a right to have their wife present or to have their spouse present. Now, Weingarten does apply within the union environment. So if the questioning has the potential to lead to disciplinary action, the individual does have a right to have a union rep present during the interview. Now, the union rep does not have the right to intervene during your interview. They can ask questions and they can consult with the union member, but they cannot derail the investigation. We typically have witnesses in our interviews, so we'll have a lead interviewer and then we have a second person as the witness. We can use that to our advantage as far as technique goes. So if one person is kind of losing rapport or not connecting with the interviewee, can always default to the second person to take over. Can always use the technique of good cop, bad cop is the advantage of two people. And then you always have two against one. So you're both taking notes. The person who's doing the talking is going to be taking less notes so they can engage with the interviewee. So you have the witness really to fall back on with those notes. And then if the individual, the interviewee, tries to recant, again, you have a second person, so it is 2 against 1. It is possible to conduct non-employee interviews. These are going to be a little bit different flavor in that you're not going to give them as much information. There's no confidentiality or retaliation or anything like that that applies. Be sure that if you're going to conduct non-employee interviews, whether they're vendor interviews or family members or things like that, that you do proceed with caution and consider all potential implications to the business as a whole before going into those conversations. So in summary, we did review the 6 methods of investigation and how each is used. So we have physical surveillance, electronic surveillance, research and audit, forensic analysis, undercover, and interviews. We also reviewed some of the legal complexities and risks associated with workplace investigations and means to diminish those risks. That brings us to the end of the presentation portion. It looks like I went pretty much exactly 45 minutes, so kudos to me for being on time with that. We're now going to move into the question and answer portion. So I do have a list of some questions that people have asked along the way. Now is also a good time if you came up with any additional questions. So let me take a minute here to look at them and see what I can't answer. Okay, so we have a question about telephonic interviews. It's kind of asking for some perspective on the process of conducting telephonic interviews. So here at Business Controls, we do conduct our interviews face-to-face as well as telephonic. As you can imagine, there are some inherent difficulties in doing it telephonically. You can't look at the person. You can't read their immediate responses. But it's still possible to look at, to be able to analyze some deception through their voice and through their pauses. I like to most frequently use the pause method, or pause technique, if you will, during telephonic interviews. So if I don't think someone's being truthful with me, I tend to just stop talking and just leave a large silence. Inevitably, people will start filling it in with things. If they're not being truthful, they at times can get people are uncomfortable with the silences, and at times they'll just start blurting out information, or else they'll continue to tell their lies, but they'll inevitably mess up their lies about their lies, and that just gives you more information to confront them with. I find, though, that we can still gather just as honest and accurate information to telephonic interviews. You want to make sure you're doing your background information, gathering your background information so you know who you're speaking to. So before going to interview, you need to know, is this an ally with the complaining party? Is this person an ally with the accused? So that you have strong context as far as where they're coming from with their opinion, and that you can make a credibility assessment of how accurate or honest you think they were with that information. So telephonic interviews are going to be a little bit harder. We tend to reserve those for issues that are more run-of-the-mill, where you have direct witnesses, things that are less complicated, more open and shut cases. When we have cases involving legal matters, fraud, theft, sexual harassment, discrimination, those types of things, we tend to escalate that to on-site interviews just to maximize the results that you're getting and the efficiency of conducting that actual investigation. So it's definitely a method. It's a way to conduct interviews. There's a lot of resources out there about the differences and different techniques to use, and I'm sure we will have a webinar in the near future going over the differences between on-site and telephonic, and how to, and some different techniques to use. All right, another question is, what is your preferred method? And what method has the best evidentiary value? So I think I kind of went over this one a little bit during the course of presenting the methods. Interviewing is definitely my preferred method. That's where you get the most information. It's the most interactive. It's the most exciting. Sitting reading through a bunch of documents, definitely I can get excited time to time, depending on what information is contained in there. But interviews is just that live action, and it's great to feed off the environment and the individuals that you're speaking with. It also does provide the best evidentiary value. Again, we're going back to trying to get the admission. So what's better than someone saying they did it? Some would say having them on video. I differ. Based for all the reasons that I explained earlier, having them on video is not as good as having that admission. It helps and it's support, but you're ultimately wanting to get that admission. Okay, so there's a question about electronic surveillance on computers, so like key logging stuff, or personal emails, social media sites, when employees are using them on their company computer. This goes back to expectation of privacy. You need to have clear policies in place that are setting forth an expectation. So you need to make it clear that if somebody has a company laptop, that is company property, and anything they do on that laptop is property of the company. You guys can seize it, you guys can look at it and review any of that information. Generally speaking, information sent from a personal email, in order to best preserve that information ethically and legally, I would recommend asking the person for their email password. That way they're giving you access to that information. But anything that they're sending over company email, absolutely, it's free range. That's stuff that you have access to. But again, be sure your policies are reflecting that information so that it's clear on what's company property and what's not company property. It can get a little bit fishy with a cell phone, so if somebody has a company cell phone that they're also using personal, make it clear that when you're issuing that cell phone that that's a company cell phone and you have access to all the information that is shared on that phone. Again, decreasing any expectation of privacy they might have. Says, can you ask an employee under investigation to sign a release for information? Absolutely. You can ask them anything that you want. Um, you can ask them anything that you want. It doesn't mean they have to sign it. Absolutely not. We want to make sure that the way we're asking does not come across as being coercive or threatening in any kind of way. But if they suggest they have some documents that's going to prove them innocent, you just simply ask, okay, well, would you be willing to share those documents, or would you be willing to sign a release so that I could review those documents? Most frequently, that would apply to some kind of credit, banking, also medical records, things like that that may be relevant to the investigation. So yeah, it doesn't hurt to ask, but make sure you're doing it in an ethical manner. Okay, so question about advice when companies are not generally disciplined with investigations, how they overcome and educate on why it's important to have the right processes in place. So there are two different approaches to this, and this is what we, are dealing with on a constant basis with our companies. So within an organization, and I'd assume this applies to most of the people who are on this webinar, there are people that get it. There are people that understand you have to have processes and procedures in place in order to protect your organization. There are other people that don't get it. They think that employees can fend for themselves, or that they have good culture and that people know what they're supposed to do. And I hate to take the approach of pain, but it takes a lot of individuals or organizations to experience the pain of litigation, to experience the pain of large settlements before they get it. So they often don't understand or don't believe that putting the money in making these processes and procedures and then training, right, because it's not good enough to have the process and procedures. You then have to train your employees and managers on how to properly use those processes and educate them on the procedures. And that's going to cost a lot of money. And until you have an end result of a monetary amount for litigation or settlement, it's hard to show the importance of it. So when we come in to do a workplace violence threat assessment, and we give a quote for how much that's going to cost, sometimes an organization, we're not willing to invest that money. They don't want to spend, $3,000, $5,000 at the forefront. How can I show that that's a good return on their investment? Well, I can't, because if I do my job right, that person never comes back and the organization doesn't have an issue. So how do I prove that investing that money in me, doing that threat assessment is going to help them? Well, what's the alternative? That they don't do the threat assessment and then something else happens and the company is now liable. God forbid somebody gets hurt or killed or anything like that, and they knew there was the potential and didn't do something to stop it. The amount of money that they're going to have to spend in that situation is going to be exponentially larger than what they spent at the forefront. So I know that's kind of not an answer. It's kind of echoing that you have the same problem that a lot of other organizations have. So it's about changing the culture and the mindset. It's about providing a productive and healthy work environment, which will equate to better numbers and more productivity in the long run. And how to make it healthy is to set those expectations, to make those processes and procedures clear at the beginning. All right, let's see. Probably have time just for one other question. How does a union environment impact what methods you can use? It can severely impact the methods that you use. You have to make sure that you are familiar with the union contract and what you can and cannot do. Every contract is going to be different, so make sure that you are familiar with your organization's contract. Hopefully you have a non-contentious relationship with your union, which might be an oxymoron, to be able to have a point of contact where you can discuss, what those parameters are, that you can have a good, intelligent discussion on where those parameters are and what you can do. So just make sure to consult that contract, make sure you're not violating anything in it. So then last question that popped up, if you ask for, I think the question is, what do you do if you ask for an employee to sign a release and they refuse to sign it? You don't do anything. You can't really do anything. You note on the release that they refuse to sign it, and I think it kind of depends on what the release is for. So again, you don't necessarily need a release to get things like criminal records, and a lot of that public domain stuff, it's kind of nice to have one. If it's at the beginning of employment, you can require that they sign that release as a condition of employment. So if they refuse to sign it, then they can just not be employed there. What you can't do is enact disciplinary action or any adverse action because they refuse to sign a release. You can explain to them that the information you need that information to make a sound decision, and if they are not willing to provide you with that information, then you're going to have to make a decision in absence of it, and then you're free to make your decision based on the facts that you have. If they're choosing not to give you other facts, then you just don't include that into your decision making. All right, we're right about at the end of the webinar, so in an effort of keeping on time, respecting your time, we're going to go ahead and end it. As I stated at the beginning, we'd appreciate any feedback. I'm new to this webinar, to the webinar scene. It's quite different for me to be talking to a computer versus talking to a live audience, so any feedback that you have I would really appreciate so I can improve upon in my next webinars. Go ahead and take a look at our website for any more information about our company or about the additional webinars that we are providing. If you have any questions, feel free to follow up, and we will certainly loop around with anyone that we didn't have time to answer their questions. Have a good weekend, and look forward to seeing you on a future webinar.